Hello, I'm Francis Seeley from GlobalNet 21, and this is one of the video interviews that we often do. And we've got with us Zena Crenshaw-Logal. And Zena is going to talk to us about the judiciary very soon. Zena is quite interesting. She's going to do some webinars with us in the future, but she started an organization called the National Judiciary Conduct and Disability Law Project. Now, that's an awful mouthful, but it's an interesting title. And Zena started it for many reasons, but I know that Zena is very concerned that today we're sort of facing a crisis in our democracy and a crisis in our executive and legislative branches, and citizens find they don't get the sort of redress that they thought they could get through those systems. And so she's looking for a different balance between those parts of government and the judiciary. So I'd just like to welcome Zena with us today. And Zena, I know you're talking away from across in America and you do a lot of work there, and you started up the Law Project. Can you tell us, first of all, why you started the project and what the purpose of it was?
Well, when we first started, our focus was going to be on apparent judicial misconduct, and we were essentially trying to create a process for bringing together multifaceted advocacy to address what we thought was judicial misconduct and inappropriate collusion between private parties, private litigants, and judges. And we recognize that in order for people who are advocating in the public interest to balance the power of average citizens versus very powerful government interests and private interests, we needed to bring to bear not only the capabilities of private lawyers, but also community organizers, marketing specialists, fundraisers. So that initially we wanted to bring about reform for the better of our legal system by multifaceted advocacy. Our purpose has changed a bit since then.
Okay. Now, obviously, you believe, as many people do, that getting redress through the other parts of government is difficult nowadays for all sorts of reasons. Globalization, the rise of populism, many other things is impacting on our democracy. Does that make the role of the judiciary important and vital now for citizens because it's a one area where they can go to for redress?
Exactly. The judiciary becomes a critical avenue for addressing public interest matters under those circumstances. And it's primarily based on two considerations. One is access, and the other is what I call oversight jurisdiction. And access relates to the ease with which citizens can petition their judiciary for relief, actually file a lawsuit or some other form of complaint. Oversight jurisdiction relates to a private citizen's ability to dispute the legality of a situation and get a binding assessment of relevant rights and responsibilities, as well as appropriate relief through court proceedings. So based on those two considerations, the ease in which we can access a judicial process pretty much by filing whatever filing fee and necessary papers, and then you have access to the power of the judiciary, and then your ability to address the legality of even government action through legal proceedings without having to go through a gatekeeper such as a legislator or a prosecutor or a governor or even a president who are vested, at least in our country, with almost absolute discretion as to whether they'll entertain your concerns.
I mean, that comes as a surprise, I would think, to many people who think that the normal way in democratic change is to lobby your congressman or your MP in this country. Why do you think that people don't understand that the judiciary is so important and it can be accessed better very often than going to Congress or Parliament? I mean, why do you think they have this misconception about the judiciary?
Well, one thing is that our judiciary is not usually the focus of broad awareness or broad scrutiny by major media. And so it sort of operates under the radar. So people are usually focused to what's happening in the executive branch, what's happening in the legislative branch, and they're just simply not aware, don't pay much attention, and they're not encouraged to pay much attention to this third very powerful branch of government. And so some people, of course, are aware that the judiciary can be used as a forum for dealing with public interest matters, but most people, average citizens, think in terms of the judiciary as just a place where you go and resolve private disputes. And so if if they're lucky enough to not have private disputes, then they don't see the broader function that the courts can role that the courts can play.
But I think the problem other people have about the judiciary is they're afraid of it because they're afraid it will cost them a lot of money. Sending a letter to your congressman or your MP costs nothing. You can send an email, but the judiciary may cost you money, and that's going to put a lot of people off, especially poor people. And in this country, legal aid is getting less and less. And for the middle class, it's even worse because you're above a certain income level, you have to start paying, and people just can't do that. They don't want to do that, so They let it go.
Exactly, and that was to reflect me not mentioning that impediment. People being concerned about cost reflects my bias as a lawyer, and I'm comfortable with pro se representing myself through legal proceedings. So you're absolutely right. Many people who are not comfortable, they may understand the nature of their legal claim and what they want to assert through legal process, but they're not comfortable doing it themselves, and it can just become cost prohibitive to involve a private attorney.
So how can you make the judiciary more accessible if that is a major impediment?
Well, we do so much. We encourage mobilization of communities, that we harness the power of grassroots advocacy, the spending power that comes by pooling our resources and challenging things as often as possible through either class actions or multi-plaintiff actions, using tactics such as fundraising. I mean, there's so many different crowdfunding and with online networks, social networks being a part of our everyday lives. There's so many options for people to be able to raise funds through small contributions for many people. And so that's one way we can balance the playing field, by taking advantage of our collective resources and our collective power. But of course, I'm very comfortable with that mode of operating. Most people are not. They want to get in, get their concerns addressed, and get out and get back to their lives, understandably so. But there's so many public interest matters, so much at stake. It's getting to the point that we may not have the luxury to be less engaged when it comes to these public interest concerns.
Well, I hope when you do a webinar with this, you'll actually do one on how communities can get together and how they can use crowdfunding and so on, because I think that's the sort of new thing that's happening. I'm sure it's happening in a very advanced way in the States, but in England, it's also beginning to happen as well. And I know lots of people have used crowdfunding, and that's been very useful. So I think any advice and help and examples you can give on that will be really valuable. You talk about the judiciary of being the refuge of the people. And do you mean a refuge in the sense you've talked about now, that communities can be empowered to use it if they go about it in the right way?
Exactly. The judiciary is the only branch of government that must stay open to us, and open courts is a constitutional provision here in the United States. Our judiciary is guaranteed to address our concerns one way or another. We may not like the outcome, but they're guaranteed to address our concerns. We trigger court action for better or worse. Our request for release may be rejected by a judge, a court, sometimes rather abruptly. But the judiciary can't refuse us consideration in the way that a legislator or executive branch official can refuse our phone calls or ignore our letters and refuse to meet. If a private citizen submits something for consideration by a court, one way or another, he or she will get an official response and a right to challenge government action or inaction before a higher court. At least that's the case in the United States. So it's just imperative that because of the openness, the obligation of the judiciary to be responsive to our concerns, as long as we meet the thresholds of paying the appropriate fees or asking for fee waivers and present the appropriate papers. It's just a vital mode of protecting our not only our personal rights but our collective rights.
So the judiciary, is important because people can get redress and they must take it up, whereas the legislature and the executive, government, parliament, Congress can ignore it if they want, or they can delay and delay and delay and delay. So it's important, you think, that people understand that can be, a very quick, well, at least a quicker way of dealing with redress than having to go through the lobbying process that might be farcical.
Exactly. And another thing I should mention is that legislators, some of them have literally one legislator addressing millions of constituents. And so it can become a practical matter that you can't get physical access to your representative. Of course, you can work with staff, but so between the fact that our representative and senators are spread out among so many constituents, and of course they necessarily have to make decisions based on priority, and so when you have lobbyists who represent big moneyed interests versus private citizens who are accustomed to living our lives as opposed to being professional advocates and doing what's necessary to harness political power, because public officials in this country, they respond to numbers. So if you don't have numbers insofar as dollars, then you need to have a lot of people acting in concert to protect their collective interests. And, that's easier said than done among private citizens who are usually most focused on their, personal lives, as opposed to working in community organizing and working on a broader basis.
So the judiciary is about the individual getting redress and not having to get involved in a lobby of a mass of people. They have a right, the individual counts. You talk about it as being a sword or a shield as well. What do you mean by that?
What I was trying to convey is that the judiciary can be a sword cutting through corruption and anything that hampers democracy and justice. On the other hand, they can shield unscrupulous people and institutions who are that threaten democracy and justice. And it's unfortunate that it's much easier for courts to be a shield than a sword when wealth and power are concentrated among a relatively few global interests. So, when I talked about the sword and shield, I'm not sure if I made that clear, that, it's a sword when it's working for the people, when it's working in accord with constitutional provisions and just, common notions of fairness and justice. But when it shields people and corporate interests and government interests that work against the collective good, then that's when things are, that's when we have a problem.
So even though there's a shield that powerful organizations can use because they've got the power and the money, it can be a sword to attack that as well, as we've seen with some of the pipeline cases in America, for example. Exactly. And people have got to learn how to use it and work with others to achieve it. And your aim as an organization is to enable them to do that?
Exactly. And it's really about, again, harnessing our collective power. Because when you have when you're defending you're protecting public interests against very powerful and wealthy corporate interests, that have a tremendous influence at every juncture of government oversight. It's more than a notion to level the playing field in that environment. But when you have a community that's, number one, just I may be suggesting that somehow we have to be litigating all the time and constantly engaged in this community advocacy, but over and beyond that, if as general citizens, if we just pay more attention to what is happening in courts and its implications for not only individuals but for us collectively, then that scrutiny will, what is that? Sunlight is the best disinfectant. That scrutiny will keep all of our government officials, and particularly our judges, on their toes insofar as not issuing rulings that are contrary to law or seem unfair.
Okay, and one final question. I mean, the thing about the legislature is that they are in theory accountable, i.e. they're subject to election. And of course, in the States, many judges are elected as well, but they're not in the United Kingdom. I mean, how can you keep the judiciary accountable without putting so many constraints on them that they don't maintain their independence? What's the process of doing that? And is that something you're concerned about and that you campaign about?
Certainly, for sure. You do it by building awareness about a range of proper judicial action, so people better understand what judges are entitled to do and what they're not entitled to do. Then you promote a proper balance between judicial independence and judicial accountability. We advocate replacing state judicial self-policing with panels of randomly selected and trained private citizens who resolve judicial misconduct allegations. We think state judicial self-policing and the inherent conflict of interest associated with that really takes away from accountability, effective accountability, and in fact is unconstitutional in this country. That's our contention. Then another thing we promote is that we select more plaintiffs, more lawyers to be judges. In our country, our bench is dominated by former corporate and former government lawyers, and so that limits their perspective. We are advocating for a diversity of perspective, even though we have great diversity insofar as gender, religion, that sort of thing. We need more diversity of perspective, and that will bring about a self correction. And finally, implementing effective judicial whistleblower protection, so that court personnel and lawyers can be protected when they try to expose judicial misconduct, but also private citizens need protection from the kind of retaliation that can be brought about when they're trying to expose judicial misconduct. In fact, our organization right now is contending that private citizens abuse of the legal system, which gets facilitated by judges not being a proper gatekeeper. So ultimately is a matter of judicial misconduct. And we contend that there are a significant number of private citizens who are literally being persecuted through persistent abuse of the legal system, even sometimes to the point of psychological torture in a global sense. So and we suggest that the problem has risen to the point that there are human rights treaty violations involved in a human rights crisis. So we need to bring protection, to effective protection for anyone who's inclined to deal with allegations of judicial misconduct, so that they're able to do that effectively and without being totally decimated by the retaliation that can come.
Okay, well, thanks for doing that. I think that was a really interesting interview, and I hope we'll do another one with you sometime fairly soon. So thank you for doing that, Zena. That was great. Zena's going to be doing quite 2 or 3 webinars with us, and we've already got one booked up, and we'll send that out to everyone. And some of the issues she's talked about today she'll be dealing with in more detail, and then people will have a chance to ask her questions and make comments. And I look forward to her doing that, and I look look forward to many people joining us and to listen to what she has to say about the importance of the judiciary and how it can help people redress grievances that they may have in a way that they didn't think that they could. So thank you again
Thank you,
for doing that, Zena, and we'll see you again very soon.